All right, hello everybody. My name is Justin Stivers. I'm the owner of the Probate law firm, which you can probably guess from the name of the firm. What we do is probate law, so probate administration, which happens after somebody passes away, and then the planning side, writing wills, writing trusts, that sort of thing, before they've passed away. And it's okay if you're not even sure what that really means. We're going to go over that. And so I've been doing this presentation for a couple of years now. I still do it in person occasionally, have a longer course that I teach for continuing education as well, but started doing it because, in Florida, we've obviously have a population, a large retiree population, an aging population, people who move to Florida from all over the country, really all over the world, buy property here for your purposes, buy a piece of real estate. They don't put it in a trust, they don't title it properly, and then when they pass away, usually their kids are unable to sell it without going through the probate process. And so, my firm, we do several hundred probates per year. 95% of them include real estate. So I know that at some point, if you're in the realtor game long enough, you're going to come across a listing or a buyer who wants to purchase a property through probate, or hopefully not, but you might have to go through the probate process yourself for a personal matter. So I put together this course, try to keep it at around 45 minutes. That's about all my attention span can be on Zoom, and you all are probably the same as well. So try to keep it about 45 minutes. We'll save some room for questions at the end. If you have any questions while we're kind of going through this, I muted everybody for now, just to, so we don't have, the kids in the background and everything, but put your questions into the chat in the meantime. And then when I finish, I'll unmute everybody or allow you guys to unmute yourself so you can ask questions as well. We'll save a couple minutes for that. But so that's kind of, my background, but the presentation, what I'm going to talk about today, Probate 101, is really three parts. So part number one, how do you even identify when a property is going to have to go through probate? So step number one, how do you even know? If you're working with somebody, how can you tell? Part number two, can you be, again, unless you're an attorney, not going to advise you to give any legal advice, but how can you know enough about the probate process to speak with your prospect, speak with your potential client, and educate them enough so that you're talking the lingo where you stand out from another realtor who's competing for that piece of business as well, right? I think you all know, there's no shortage of realtors anywhere here in Florida. You've got a lot of competition, but not all competition is created equally. And so if you can kind of differentiate yourself and just educate the client about what probate is, answer some basic questions, put them in contact with, your preferred professional, you'll stand out. So we'll talk a little bit about the probate process. And then lastly, the third part, just some basic marketing ideas, maybe some just simple recommendations so that you all can find probate listings, because at the end of the day, you all probably want to get more listings. I get that. So before we kind of dive into part one, let me just give you a couple key definitions, a couple quick things that I think would be helpful for you to know. So what is probate anyways? Like I said in the very beginning, probate is a court process. It occurs after somebody has died. So when you hear the word probate, that means there's a court involved. There's a judge involved. There's likely an attorney involved. And again, for your purposes, what we're doing is we're taking an asset, in this case, a piece of real estate that was owned by somebody. They've now died, and we have to transfer the property to the new owners. So usually it's, mom and dad died, they owned a piece of real estate, they've both passed away. Now the kids want to sell it, rent it, do whatever with it. They don't just automatically get to become the owners because their parents died. There's a probate process. So when you hear probate, unfortunately, it means there's a death that's involved. Estate, so ESTATE, estate. That's just what we're going to refer to the entire, everything that a person owned, right? So when John is alive, he owns his house, he owns his car, he owns bank accounts, money, all of that sort of thing. When John dies, we refer to all of that as the estate of John. So the estate of John Smith. And so again, for your purposes, and we'll touch on this a little bit later, When we talk about signing listing agreements, when we talk about signing as-is contracts, we're going to refer to the estate of. Last will and testament, or just commonly referred to as a will, just who gets what of your stuff. And so we're going to talk about that. You all are probably familiar with what a will is, but a last will and testament, who gets what of your stuff after you pass away. And then probably, last and probably most important is what we're going to talk is something called the personal representative. Some states use the term executor. You might hear the term administrator. In Florida, we use the term personal representative, but because I'm going to say it a lot during this presentation, we use shorthand and we just call it the PR. So the PR means personal representative. And what the PR is that's the person in charge of administering the estate. So the PR is usually going to be the person who hires me. And for your purposes, the PR is the person who's going to usually pick the realtor. The PR has to be named by the court. So the court is going to name who the PR is. And that's very important because, as we'll talk about a little bit later, you want to make sure that you're working with the PR because, again, they're going to be the ones who will sign the listing agreement, sign the contract, and even before then, pick the realtor. So those are some key definitions that I think will be helpful for this. So part number one. So how do you guys and girls identify when a probate might be necessary, right? So how do you even know? Well, first, maybe easiest is if someone just tells you, hey, my mom just passed away, I want to sell this property, or that the owner of the property has died, chances are probate's going to be necessary, but that might not always be the case. So if we were in person, I'd probably have you all raise your hands and say, what's the first thing you do when somebody calls you and says, hey, I want to buy this property or I want to sell this property? And most people are going to say, they're going to look at the deed, they're going to look at the title, they're going to go to the property appraiser's website, they're going to go to the tax roll and see who actually is the owner of the property and maybe do a little bit of digging. Same thing here. We're going to look at the property appraiser's website and we want to know who the owner is. So I'm going to share my screen again for those of you who are maybe just on your phone. Make sure we have your email, give it to your broker, and then he or she can pass it to us after, and I'll send you a copy of the recording so you can look at it if you're unable to see it. But I've got a couple examples. I'm just going to share my screen. We can look at just a second. All right. Okay, so first example here, if we're looking at the owner, in the owner's box on the property appraiser's website, you're going to see a person's name, Maria Pichardo, and then after that, you're going to see the letters EST and then the word of. So Maria Pichardo, EST of. Probably could guess the EST stands for estate. Okay, so we talked about estate a second ago. What estate means. 99.9% of the time, if you ever see the words EST of after somebody's name on the property appraiser's website, probate's going to be necessary. So that's exactly what happened here. Maria passed away. The property appraiser found out that she passed away. They updated the title to reflect that she passed away. So now if anybody, it's since been transferred, but if at this point, if anyone wanted to buy this property or the kids wanted to sell the property, they're going to have to go through probate. So this is probably one of the most common designations that you'll see as a, no pun intended, kind of dead giveaway to know that the property is going to need to go through probate before it can be sold. Now, I get questions all the time. Well, how does the property appraiser know that the person's passed away? When do they update the records? The truth is, I don't know the exact answer to it. What happens sometimes is a person whose parent passed away might go to the county and say, look, my mom, my dad passed away. Can you put the property into my name? Either because they don't know they have to do probate, or maybe they want to keep the homestead exemption tax, right? So you all probably are familiar, but homestead tax, you get a discount, you get an exemption if it's your primary residence. So a lot of the time, if the kids are living in the house with their parents and their parents pass away, they want to make sure they get the property in their name so that they can continue with the exemption. So they go to the county, tell them, hey, look, mom died. And the county is going to say, oh, sorry about that, but you're not the owner. Now you lose the homestead exemption. And now we're going to update the records to reflect that the owner passed away. So that happens a lot. Sometimes the government organization that records death certificates in Jacksonville, called Vital Statistics, they've told us that they mail certain information to the counties when someone's passed away. I don't know if that's 100% true, because I've seen people who passed away, 10, 15 years ago, and the county has never updated the records. So hard to say. But if you do see this, if you do see the EST of, like I said, this is going to be one of the most common things that you're going to see to know that probate's necessary. All right, second example, I can open it. Okay, under the owner's name, we're going to see Jesus Silva EST of, and then under that, we're going to see Maida Silva. So we just went over what EST of means, estate of. So we could tell by looking at this that Jesus, we can presume, has passed away. But in this case, there's another person on title. And this happens all the time. People own real estate together. Now, this is an example. This is father-daughter, okay? Father and daughter own the property together. And I'm going to talk a little bit about the different ways you can own title together. But the legal way they own this is what's called tenants in common, which basically just means that when one of the persons died, their 50% did not automatically pass to the surviving person. So Jesus and Maida own the property 50-50, but when Jesus died, his 50% didn't go to Maida. Now, she didn't realize that. She thought that, dad wasn't married, mom had died, I'm the only daughter, we're on the property together, so I should inherit the property. She gets a realtor, they go through, they get a buyer, they go to the title company, they go to closing, and you can guess, title company said, did you do a probate for Jesus? They did not. Now they got to go back and hire a probate attorney to go through the process to transfer the property to her name. Happens all the time. A lot of people just don't know it. They just think I'm automatically going to inherit it. So again, when you're looking, it's really the deed that's going to be the most instructive as to whether or not probate's going to be necessary. So you can't rely 100% on what the property appraiser puts in terms of the owner, because they don't always do 100% accurate job. I'm sure you all have found that out, in your work if you've been doing it for a while. So the title company, they're going to find that, they're going to see that, and they're going to see that the deed did not have certain language on it. Like I said, it was just called tenants in common. So what they could have done very easily, if they wanted to, they could have made the deed say Jesus Silva and Maida Silva as joint tenants with right of survivorship. So it's a very simple language. It's called joint tenants with right of survivorship. And what that means is if one of the owners dies, his or her 50% automatically goes to the surviving person. And when that's done, probate's avoided. So if Jesus and Maida in this case had just put very simple language, Jesus and Maida as joint tenants with right of survivorship, she would not have had to have done probate in order to transfer the property to her name. When Jesus died, she would have automatically been 100% owner. So so if you've got that language, if you have that joint tenants language on the deed, you're not going to have to go through probate. So that's something to look at. There's a couple other deeds that can also avoid probate. One of them, they're very similar names. One of them is called a life estate deed, and one of them is called an enhanced life estate deed, or you might have heard the term Ladybird deed. And what that basically means is you own the property and you put somebody else on the property. They don't have any ownership interest while you're alive, but when you pass away, they become the owner. So for example, if I have if I own a property, Justin Stivers individually, and then I put, let's say a brother on there as a life estate, then he can't do anything with the property. If I want to sell it, I don't need his permission. I can take him off of the title if I want to, but once I die, he automatically becomes the owner of the property, and he doesn't have to go through probate. So those are two other deeds. So, we don't have to, I'll answer any questions on those here in a second, but if you're looking at the deed and you see some of that language, then probate's not going to be necessary. And then the last one I want to mention, last example here, is we're looking here and we see, excuse me, Karen S. Rodman, and after that we see the letters TRS, and then under that we see Karen Rodman, BEN in parentheses. The TRS stands for a trust. So you all might have heard of a revocable trust, a living trust, a revocable living trust, an irrevocable trust. There's a bunch of different titles depending on what you're doing, but most commonly in real estate, you're going to have what's called a revocable trust. And what that is, it's very similar to a will in that it says what happens to your stuff after you pass away. So remember in the beginning, I talked about what a will is, who gets what of your stuff after you pass away. A trust is like that. A trust is going to say, who gets what of your stuff. But there's a difference. A will does not avoid probate. And so a lot of people don't realize that. A lot of people get a last will and testament. They write down, hey, I want my kids to have the property. The parents pass away. The kids have a will, but the county is not going to update the records. The kids are still going to have to hire an attorney and go through the probate process to transfer the property to their name. And a lot of people don't realize that. So wills have a purpose, but if your goal or your client's goals, or you personally, is for whoever you want to leave your stuff to, if you don't want them to have to go to court, you don't want it to be public, you don't want everybody to know what you had and fighting amongst the kids and all of that, a will is probably not the best thing. So what a lot of people will do, and again, this isn't just for the rich and famous, a lot of people, even if all they have is just one piece of real estate, they'll do a trust. And so the difference again between the will and the trust is if she just owned the property by herself, it would just say Karen S. Rodman. But what she did, and you can see back here, it doesn't show it, but she just transferred the property from herself to the trust. So what she did is she made the trust the owner of the property. So Karen S. Rodman individually doesn't own the trust. The Karen S. Rodman Trust owns the property. And then it just so happens, the person she's leaving the property to, the people she's leaving the property to is Karen Rodman. So that the BEN stands for beneficiary. And so that's the difference. That's the difference between those two. So that's a big thing. If you have the property into a trust, you'll avoid probate. So let me stop sharing for a second and just see if there's let's see any questions if you want to ask up to this point. You can unmute yourself if you have any questions. If not, we'll carry on. So someone asked, what are the pitfalls with a Ladybird deed versus a trust? Well, yeah, so a Ladybird deed is, again, it's a good question. It's going to say, you own the property, but then when you pass away, the person you've named as the beneficiary gets the property. So that works. Same with the trust. The difference is, let's say that maybe you have specific things you want to do with the property. For example, like if you just want to leave the property to one person and that's it, and you want to leave the property to your sister and that's it, a Ladybird deed is probably fine for purposes of the property. But let's say you've got 2 kids. And so clients come to me and they say, hey, listen, I just want my kids to have the property. Okay, perfect. And they're like, I just want them to have it 50-50. Okay, no problem. If you do a Ladybird deed and they get the property 50-50, now they are joint owners. Okay, and so if one of the siblings, let's say sister doesn't want to sell the property, she's not doing so well financially, she needs to live in the house, but brother wants to sell the property. He doesn't want to pay for the mortgage or pay the taxes and everything. If they can't agree on what to do with the property, Now there might be in a lawsuit to try to force the sale of the property, or at a minimum, they just hate each other because now they can't agree on who's going to maintain the property, pay the taxes, and everything like that. If you do a trust, a lot of times what we do for our clients is we'll put language in the trust that says, just as an example, we'll give the siblings 60 days. If one of them wants to buy out the other, he or she has to get an appraisal on the home and take out a mortgage if they're unable to, or take out a loan to buy the other person's interests out. If in 60 days they can't agree, then the person in charge of managing the trust is instructed to, do an appraisal, hire a realtor, sell the property, and then give the proceeds, 50-50. And so that way you can kind of take out some of the, disagreements that might happen between the families. So between the family members. So that's one thing. So let me see this. I know we always get a lot of questions on trust. So let me answer this one real quick, and then we'll kind of move on, so I can continue. So in the trust example, the owner was also the beneficiary. If the owner passes away, no, it's different. So it's a weird example. The example that I showed you, it's actually two. It's mother and daughter. They just happen to have the same name. They're saying, hey, Karen S. Rodman and the Karen Rodman. They just happen to have the same name. But normally the property appraiser doesn't put the beneficiary on the property appraiser, because one of the reasons you do a trust is you don't really want people to see all of the things. So I don't know why the property appraiser put that beneficiary on there, but it is two different people. All right, last one here. If I have a listing now where the county record said life estate, hard to kind of answer personal questions going on right now. I have a listing now where the county records say life estate, but the deed is a quitclaim deed, and I'd have to learn more about that one to kind of give you an answer on that. So, all right, so let's continue now. So let's say that you've determined that probate's necessary. Okay, you've gone through you've looked at the county records. You know that probate's going to happen. So at this point, let's say that you're in the position where they don't have anybody that they're working with. They might not even know probate's necessary, and that happens all the time. I had a call, often, but just yesterday, where they were at the closing table and they didn't know that they even had to do probate. And so it came up, and now, they're 6 months into the deal and they realize now they got to do probate. So you might be in a position where you can kind of educate the client about some things that they can do. And so again, goal of this is not for you to, tell them, hey, do this, but just to kind of get the conversation going. So a couple of things that you're going to want to ask, that I always recommend that the realtor just ask the client. So remember, you want to make sure that you're working with the PR, the personal representative, because the personal representative is the person who gets to hire the realtor. And so if you're not working with the PR, then you might not get that listing anyways. So here are the questions. You want to first ask, is there a last will and testament? Did the person die, have a will? And the reason you want to ask that is because, let's say you're working with brother, and brother is, dad died, and dad and brother tells you, yeah, me and my dad were really close. He was my best friend. He promised me the property. It's my family home. I don't have any other siblings. Okay, did dad have a will? Turns out he has a will, and dad was having, affair with a waitress down the road and left the property, to her. Well, now, even though they were close, even though him and his brother, him and his son were close, there's a will that says the waitress in this example gets the property. So now the waitress is the one who's going to pick the realtor. So you want to make sure we want to find out if there is a will. If they say there is a will, we want to ask them if they have a copy of it. And the reason is, wills are not recorded. Okay, so generally wills are not recorded, and they're not stored in court records. When we do a will, for example, I'm going to draft a will for somebody. They're going to come into my office. They're going to sign it. I'm going to make electronic copies. I'm going to just store that on my on our hard drive, so that we keep copies of it if we ever need to make changes. When they go home, if they put that will, in a drawer next to their bed, and nobody knows that they had the will when they passed away, family's not going to know that there was a will. And so if they don't have a copy of it, there's not going to be a way for us to use it, or use, for the most part, someone just telling me, hey, my dad had a will, but I can't find it. So we need to make sure that they have a copy of it. They don't have to have the original necessarily, but they do need to have a copy of it. So those are the first two things I would ask. Do they have a will? And if they did, do they have a copy of it? The second thing I'm going to ask is, what's your relationship to the person who passed away? And so the reason I'm going to ask that is because in Florida, there's a hierarchy of who gets what. First, it's going to be the surviving spouse. Then it's going to be the children. Then it's going to be the parents, then the brothers and sisters, on and until you get out to second and third cousins. Okay. And if you're speaking with a second cousin, and the second cousin tells you, my cousin didn't have any close family members. I think he had a kid, but the kid, moved to California 30 years ago. No one's seen or heard from him. Well, that kid still has priority to become the personal representative, even if he doesn't have anything to do with the parents. So you want to make sure that you're speaking with somebody who's in close relationship, because if there is no will, again, there's a hierarchy. And I get calls all the time from investors or people who say, hey, my neighbor just died. I want to buy their house. I don't think they had any family member. Can I buy the property? And I say, well, maybe, but you're going to have to find who the next of kin are. We can't just go to, even if there was a mortgage and they tell me yeah, but the property's, they're going to lose it to foreclosure, or the county's putting liens on the property, or, they haven't paid their property taxes. They're going to take it, and there's nothing you can do. We still have to have the heirs, the next of kin, who's going to have to go through this process. So that's the next thing you want to ask. What's your relationship with the person? All right. So now we've kind of, let's assume now we've figured out that we're working with the PR. And one other thing on that is, just because a person has a will and it says that they are the representative, we still have to go to court, and the judge has to say it's a valid will and sign a piece of paper naming that person as the PR. So just because someone comes up to you and says, hey, look, I'm the representative, I'm my dad's only son, there's nobody else, even if they have a will, if there's not been a court process and they haven't had the judge sign a piece of paper saying that they're the representative, that's not good enough. So that's just another thing to know. So our children and stepchildren at the same level. Stepchildren really don't have any rights. So unless they're legally adopted, or the parent has taken some sort of affirmative action to claim that child as their own, they're not going to have any legal rights. All right, so let's say we've determined that we're working with the PR. Clients are probably going to ask, well, how long is this going to take, and what's involved? So the question about how long it takes is really kind of dependent on one factor, which is, when did the person die and when are we doing the probate? So there's two examples. The first example is the person died more than 2 years ago. So let's say, we're in 2021. Let's say the person died, in 2015. So it's been more than 2 years. On average, it's going to take about 4 months in that case. So it's going to take about 30 days to get the person named as the representative. And then we're going to be able to transfer the property probably in the next 30 days or so. So it could be a little bit quicker. It could be, 3 months, 2 to 4 months, probably not 2 months, just because, again, I do these in almost all 67 counties in Florida, and the courts are almost equally as slow in every single county. And so they take a while. And so even though it should be a relatively simple process, it takes a little bit of time sometimes. So if the person died more than 2 years ago, we're going to ask the court to name the person as the representative. And then we're going to ask the court to authorize the transfer of the property, to sell the property, or just to transfer it to the new owner's name. So let's say about 3 to 4 months if the person died more than 2 years ago. But more commonly, you're probably going to be dealing with a probate where the person died more recently. So we're in 2021 and the person died, in 2021 or in 2020. It's going to be a little bit longer. It's probably going to be about 7 to 8 months. And so process is kind of still the same. It's going to take about 30 days for us to get the PR named, okay, before the judge will approve the personal representative, about 30 days. But then from there, we have to wait 90 days. And during that 90 days, what we're doing is we're waiting to see if this person who died had any creditors, had any debts. So did he or she owe money to Visa, Home Depot, IRS taxes, anything like that, any money that was allegedly owed. And during that 90 days, for the most part, we're not going to be able to transfer any real estate. We're not going to be able to go forward with the closing until that 90 days is up. Once that 90 days is up, so now we're more or less in month 5, now we'll be able to sell the property once that 90 days is up. 30 days to get the PR named, another 90 days for that creditor period, and then we'll ask the court to transfer the property. So for creditors, the good news is if it's a person's homestead property, if it's a person's primary residence, they can't do anything to that property. They can't get paid from the sale. They can't put a lien on the property or do anything like that. If it's homestead, it's protected. The only people who can go after homestead property is essentially the IRS, unpaid property taxes, HOA, homeowners association dues, or mortgage, unpaid mortgage lenders. They can make a claim on the property, but credit card companies, hospital bills, they can't do anything to go after the property. So you'll still get your commission. The client selling the property is still going to get their portion from the sale, and they're protected. Now, second homes, investment properties, those could potentially be subject to creditors. So that's just something to know and to kind of watch out for. But for the most part, you'll probably be dealing with homestead properties, probably not as many second homes. And then, so for your all's purposes, what do you need to do differently? What's different about this for you all? Well, when you sign the listing agreement, remember, it's got to be the PR. So whenever he or she signs it, let's say David is the personal representative and John is the person who passed away. So what you would put in the listing agreement is you would say David as the personal representative of the estate of John, right? Or something to that effect. David as the PR of the estate, David as PR of estate of John, whatever it is. Because David's it's not him selling it individually, it's him selling it as the personal representative. So that's what you need the listing agreement to say. If he has not yet been named the representative, because remember the court has to name him, what I usually tell realtors is just add the word proposed in front of David. So if David hasn't yet been named the personal representative, but obviously you want to get him signed as a client, you don't want him going somewhere else, you might put David as the proposed PR of the estate. And then once he becomes the PR, then maybe you want to update your listing agreement. The as-is contract, at this point, hopefully, the PR should have been named. So same thing. Now you're just going to put David, the seller is David as the personal representative of the estate, David as PR of the estate of John, something like that. And then every document going forward will have, well, for the most part, it's going to have him named as the PR. Maybe in the contract, I forget which paragraph it is. I think paragraph 8 in the Florida Bar contract, where it's just additional info, additional items. You might put something in there that says subject to court approval, subject to probate, something like that. Very simple, but hopefully, if there's a probate attorney involved, he or she can kind of say, hey, just put this language in there, but very simple language. But other than that, for your purposes, it's really, the process isn't going to change that much, other than these are generally not quick deals. And I see a lot of realtors get frustrated by them because, especially in this market, they put up the property, they have 30 buyers all wanting to get it, and they go under contract, and now the seller wants to sell it right away. But wheels of justice move slowly, and so the probate process is not an overnight process, and it can take time, and there's a lot of unforeseen things. We might have sibling fighting, and they're raising the issue, or maybe we started the probate and now a distant cousin shows up with a alleged will, and now we gotta debate whether that will was valid, or maybe mom signed a will, but she had Alzheimer's when she signed the will. So there's some fraudulent stuff going on. So sometimes there's a lot of things sort of out of our control that can, lengthen the process. Hopefully not, but I do enough of these that more often than not, there's usually some sort of issue with that. That's kind of the nuts and bolts of it. As far as marketing for probate and different things that you can do, depending on your area, you've probably got probate attorneys in your area. They generally are probably good referral sources for you all, because like I said, they're handling a large amount of probates. And I can speak for myself, but probably also for other probate attorneys, you like to work with somebody who can handle the process, who knows the process, who can help kind of manage the client's expectations. They've been through the process before. Last thing I want is, because I don't do any title, I don't do any real estate, I hate the title world. And so whenever I, start getting 50,000 emails from the title company, I like the realtor who I'm working with to say, hey, let's stop emailing him. Email me, I'll take care of this sort of thing. So that's kind of an add, a value add that maybe you can do. You can also, depending on what county you all are in or which counties you work in, generally you can go to the property appraiser's website. In the search bar under owner, you could just type a state of, and that's generally going to list all the properties that are owned by estates. And so you could generate a list, and from there, do mailers, do door knocking, do flyers, some different types of tactics that you might have to reach out and say, hey, listen, again, you want to be a little empathetic, because this could be mom who just died, and now you're, trying to contact daughter who's, mom just died 2 days ago. You probably don't want to come in with aggressive of, hey, I've got cash buyers, I can sell this thing for you tomorrow. That might not be the strategy I would personally employ. Maybe you want to be a little bit more, graceful in your approach, but you could get a list and go in and say, hey, listen, don't know if you know it, but you have to go through probate. I've got a team that I work with, I'm experienced with this. And so you could get a list to go that way. And then lastly, I've seen people buy lists. This is public record. So you can buy lists that have the attorney who's handling the probate and who's also the personal representative who's handling the probate. And you can get both of their information. You can either buy that information, or if you're savvy enough, you could probably even go find that information, go to the courthouse and pull that information. So those are a couple ideas, but hey, perfect. Right when I said we stop, 11:40. Save a couple minutes for questions if there's any. Let me just scroll through, see if there's anything. So tax ramifications for a joint tenant deed. I never like to give tax advice. I'm not a tax professional, so I always recommend CPA or tax attorney for that. How many ways are there to file probate, and what is the approximate expense for each? There's a couple different probates you can file, but for your purposes, I would just say there's one. Do the probate that transfer the property so that you can sell it. And as for fees, it depends. They range on complexity. So, you could find a probate and it could be $5,000, or you could have one that's, much higher than that, just because there's a lot of fighting siblings or something like that. So really kind of a big range. So can't answer that 100%, but most probates are probably going to be under $10,000 for the most part, somewhere around there, I would say. All right, anything, and I put my information in the chat, my email, if you want to reach out, it's just justin@probatefirm.com, or if you want to go to our website, probatefirm.com, to learn more about us. And again, make sure if you hadn't register your email with your broker, and so we'll get that information, and I'll send you a copy of this recording as well. But without any other questions, going once, going twice. Well, I appreciate your all's time, and if you have any questions, feel free to reach out, and look forward to hearing from you all. Thank you all.